I'm Frank Hartman with the Hartman Law Firm, and I'm a practicing attorney in Charleston, South Carolina, specializing in auto accidents and personal injury. Today we are going to talk about yet another Supreme Court case with Fourth Amendment implications, this one being Maryland versus Bowie. In this particular case, the Supreme Court, again with the Fourth Amendment, has taken the stop and frisk doctrine and it has applied it to not just you being out on the public roads or in your car, but it's actually extended it into your own home, which, as I always thought, was a man's castle. But certainly that doesn't appear to be the case now. The Fourth Amendment, as written, states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." That seems pretty clear to me, but apparently that's not the case, as the following case will demonstrate. The Supreme Court was taking up a case that was presented to them by the Maryland Supreme Court, and they took it up on a writ of certiorari, as the court does when there's an issue that it feels it needs to be addressed. These two gentlemen robbed a pizza joint, and the funny thing about the case is, for whatever reason, one of the burglars decided to wear a red running suit while he conducted this particular crime. That red running suit actually played a critical role in the case that was to follow. The police officers then go about their business in determining who it was that actually robbed this particular pizza joint. And they come down and they find out that Mr. Bowie and another gentleman they suspect are the two people involved. And they go to Mr. Bowie's residence and they knock on the door and there's no one there. But they go ahead and they go in anyway. They search the entire premises looking for the individuals in particular that they're looking for. But in the process, they're also looking for evidence. What does this imply? It implies what's called the plain view doctrine. And the plain view doctrine has to do with the fact that if a police officer in any context, whether it be on your person, in your vehicle, or in your home, if he comes into your home and there's evidence of a crime that has been committed that is in plain view, he can take that evidence without a warrant, without probable cause, because it's right there and it's in his eyesight, and he doesn't need probable cause because, you know, evidence is evidence and it's readily apparent to him. What's interesting about this particular case is that included looking underneath beds, looking in closets, going in every room, every nook and cranny, looking for people that clearly were not there or any evidence thereof. There was no evidence discovered, I might add. The police then knock on the basement door twice, and upon the second knocking, someone down in the basement says, "Yeah, who is it?" And they say, "Come out with your hands up." Mr. Bowie comes out with his hands up, and they place him under arrest and they take him out of the home. And herein lies the question. The police officer then goes down into the basement, quote unquote, to determine if there's any other potential people that might be down there that would pose a risk to the police. And while he is down there, he discovers the red running suit in full view and seizes the red running suit as evidence against Mr. Bowie, because he's the defendant, and obviously the defendant wore a red running suit when he robbed the pizza joint. Should that evidence have been suppressed under the Fourth Amendment? The Supreme Court of Maryland actually reversed and said that yes, that evidence should have been excluded. And then it went up to the Supreme Court of the United States of America, wherein the Supreme Court determined that out of an abundance of caution and with the idea of protecting police officers, that the police are allowed to go and do a cautionary sweep throughout an entire home to protect themselves, essentially, and that it's okay if they discover in that particular cautionary sweep, if they discover any evidence that's in plain view, that's not in violation of the Fourth Amendment. I would have you go back and read the Fourth Amendment again, because I don't hear any language in there that sounds like it could be interpreted to suggest such a thing. It seems pretty plain on its face, but as you'll note, this particular case happened in 1990. So this was 20 years ago. This is not, ancient law. I think you can see the trend from case to case as the Fourth Amendment is slowly but surely whittled away by the Supreme Court. And what that means to you as an individual American is that your Fourth Amendment protections essentially are non-existent, because what's happened is the exception has become the rule. There's 50 or 60 different exceptions to the Fourth Amendment that go to your home, that go to your car, and that go to your person. And by the time you finish going through all of those Fourth Amendment exceptions, there's very little protection for you left under the Supreme Court precedent or the Constitution as it stands. And the American public needs to be aware of that, and more importantly, they need to be informed of it, and they need to talk to their representatives about it, and there needs to be a pushback. I'm Frank Hartman with the Hartman Law Firm, and today we discussed the case of Maryland versus Bowie and the Plain View Doctrine. If you're interested in this topic or any other topics of law, including auto accidents or otherwise, please feel free to pick up the phone and call me at 843-300-7600, or feel free to look me up at thehartmanlawfirm.com. Thanks for watching.